Last week I tackled a tricky question. Is the Supreme Court just another political battlefield? Many of you push back, arguing that recent decisions prove the court has become hopelessly divided between conservatives and liberals. So this week we're testing that idea again against the data. We'll look at the last two full Supreme Court terms and see whether the justices are truly split along partisan lines, or if that popular narrative misses what's actually happening inside the marble halls. And if you listen to pundits, you'd think the court spends every term locked in ideological warfare. But the numbers tell a very different story. Across 2021 to 2022 and 22 to 23, the justices often agreed far more than they fought. Unlikely alliances formed, odd friendships deepened, and many so-called divided rulings weren't divided along political lines at all. Today we'll start with the numbers, then explore the surprising personal and philosophical partnerships shaping the court behind the headlines. Now I hope by showing you the court's 2021 to 22 term and 22 to 23 term that we get up to speed to more modern data. This year's term has just started. Last year's term is too soon to delve into for full analysis, but we're getting into fresh data that shows that these trends of consensus building among the justices seems to be the norm, not the exception. Now remember, this channel isn't about feeding your political echo chamber with quick hit drama or tribal cheerleading. There are endless channels for that. Instead, we're diving deep into the real story because understanding how institutions like the Supreme Court operate in civil society. Instead, we're diving deep into the real story so we can understand how institutions like the Supreme Court operate in civil society. Think about it. Why do we easily buy into the idea that the court is always split red versus blue? It's mostly in our heads. Psychologists call it confirmation bias. We're hardwired to seek out information that confirms our gut feelings, especially in a world flooded with polarized headlines. Take blockbuster cases like Dobbs overturning Roe v. Wade, or the Harvard affirmative action case. These explosive rulings grab the spotlight, fueling outrage and clicks, while the court's everyday agreements on technical issues fly under the radar. Media loves conflict because it keeps us scrolling, but our brains eat it up too, prioritizing juicy fights over boring stats. The result? We overlook the real data. This mental shortcut is why the partisan court myth sticks around, even as data reveals a more collaborative reality full of surprises. So stick with me. We'll examine what reality informs us about the court. Let's start with the 2021 to 2022 term. This term did show historic divisiveness in a few high-profile cases, but it also delivered some surprises. Only 29% of the cases were decided unanimously, the lowest unanimity rate in decades. In fact, for the first time in recent memory, 9-0 decisions weren't the most common. Instead, 6-3 rulings became more prominent, about 30% of cases. Most of those 6-3 splits, 14 out of 19, did fall along the expected ideological lines, the 6 Republican-appointed justices versus the 3 Democratic appointees, contributing to that term's reputation as contentious. Yet, there's another side to the stats. 17% of that term's decisions had 8 of the 9 justices in agreement. Add the unanimous decisions, around 29%, and you're at 46%. In other words, nearly half of the cases were resolved by lopsided majorities, 8-1 or 9-0, which can hardly be called a divided court. And even in the 10 cases that were 5-4, 7 were crossover decisions in which 2 conservative justices joined the 3 liberals in the majority. These numbers show that narrow partisan splits were the exception and not the rule. Now, these aren't meant to add up to 100%. We're looking at specific percentages to be able to understand how the court rules. Let's go to the 2022 to 2023 term. The very next term saw a striking rise in consensus. The court issued 57 signed decisions, and about 48% were unanimous in roughly half of all the cases. That's a big jump up from the previous term's 29% unanimity rate. Only 12 cases ended in a 6-3 decision, and in fully half of those, the majority was not split along partisan lines. In fact, only 5 or 6 cases, around 10% of the docket, featured the classic 6 conservatives versus 3 liberals divide. Overall, 56% of the decisions were decided with 8 or 9 justices in agreement, meaning well over half the term's outcomes were broad, lopsided majorities. Even many hot-button issues saw consensus. For example, all 9 justices agreed that the FTC could be challenged in court by targets of its enforcement. That's Axon v. FTC in 2023. And all 9 agreed to curb fraud under the False Claims Act in another case. By the term's end, the liberal justices were in the majority around 80% of the time, a rate of agreement higher than any Democratic-appointed justice had seen in years. These outcomes underscore that the court center held strong. Multiple analyses from legal scholars and think tanks have examined these trends, and their conclusions are illuminating. Far from being a red versus blue free-for-all, the Supreme Court often shows a united front on many issues. Broad consensus is common. Historically, about half of all Supreme Court cases each term are decided unanimously, and that held true in 2022 to 2023. Even the tumultuous prior term had nearly 1 out of every 2 cases end with 8 or 9 justices on the same side. This suggests that many legal questions, even some controversial ones, are resolved by bipartisan agreement on the law. Not all 6-3 opinions are created equal. When we do see 6-3 outcomes, it's wrong to assume they always break along party lines. In the 2022 term of 12 6-3 decisions, at least half featured a justice crossing over to join the other side. In other words, in about 6 cases, the majority included at least 1 liberal justice voting with conservatives or vice versa. Those weren't ideological lockstep votes, but principled disagreements that cut across the usual divide. By contrast, the previous term, 21 to 22, had more 6-3 rulings, and more of them were ideologically polarized. The fact that this trend reversed in 22 to 23 shows that the court's dynamics can't be boiled down to a simple partisan narrative year after year. Now, the voting patterns of individual justices underscore the court's complexity. For example, Justice Brett Kavanaugh was in the majority 95% of the time in 22, more than any of his colleagues, and he frequently provided a pivotal vote. Notably, Kavanaugh voted with Chief Justice John Roberts 95% of the time. No surprise there. He also voted with liberal justices Kagan and Jackson around 80% of the time, roughly as often as he voted with arch-conservative Justice Samuel Alito. In fact, the colleague Kavanaugh agreed with least with Justice Clarence Thomas. This is hardly the profile of a justice driven purely by partisan loyalty. Similarly, Chief Justice Roberts agreed with Justice Kagan 82% of the cases, more than he did with his fellow conservatives, Alito 78%, Gorsuch 76%, or Thomas 75%. Then there's cross-ideological voting. Even in divisive areas of the law, we saw surprising lineups. For instance, in Allen v. Milligan in 2023, a major voting rights case, Chief Justice Roberts and Justice Kavanaugh joined the 3 liberal justices to form a 5-4 majority that upheld a key provision of the Voting Rights Act. And in Moore v. Harper from 2023, which rejected a somewhat extreme theory of state legislature election power, these 2, plus Justice Amy Coney Barrett, all joined the liberals for a 6-3 majority. Conversely, liberal Justice Jackson showed independence by siding with conservatives in technical statutory cases. For example, she teamed up with Justices Thomas, Gorsuch, Alito, and Kavanaugh in a trademark case, Abitron, to limit U.S. law's reach abroad. These cases didn't get the front page coverage of more controversial decisions, but they reveal a court where coalitions shift issue by issue. The justices are not voting in lockstep with the political party platform. They're converging around legal principles that sometimes unite unexpected allies. In some, respected court watchers and studies confirm that the Supreme Court's work is far more often characterized by consensus and nuanced coalitions than by 5-4, 6-3 partisan splits. The most contentious cases may dominate the news cycle, and you might pay attention to them, but they don't represent the bulk of the court's decisions. Statistics tell only part of this story. To really appreciate the Supreme Court's collegial, nonpartisan ethos, consider the human side of the bench, the personal relationships and unlikely alliances that have formed among justices with very different philosophies. These odd couple pairings not only lead to unexpected legal outcomes, but also to heartwarming stories that underscore the court's culture of mutual respect. So here's a few striking examples. Antonin Scalia and Ruth Bader Ginsburg. Justice Scalia, an outspoken conservative, and Justice Ginsburg, a liberal icon, famously bonded despite their judicial differences. They shared a love of opera, fine food, and New Year's Eve celebrations with their families, even riding an elephant together on vacation in India. Scalia once joked, "What's not to like about Ruth except her views on the law, of course." The friendship was so deep that Scalia had a tradition of giving Ginsburg 24 roses on her birthday every year. When asked what good that gesture did, since they rarely agreed in 5-4 cases, Scalia replied, "Some things are more important than votes." This odd couple's camaraderie, rooted in mutual respect and a shared devotion to the Constitution, albeit interpreted differently, is a powerful reminder that principled disagreements need not preclude genuine friendship. On today's court, Justice Sotomayor, one of the most liberal members, and Justice Thomas, the most senior conservative, sit at opposite ends of the ideological spectrum. Yet Sotomayor has publicly praised Thomas and even calls him a friend. "I have probably disagreed with Justice Thomas more than with any other justice," she admits, but she cherishes their friendship because Thomas is a man who cares deeply about the court as an institution, about the people who work here. Indeed, colleagues note that Thomas's warm, affable personality behind the scenes has endeared him even to those who vehemently oppose his views. Their unlikely bond underscores that civility and affection can transcend ideological disagreement. It's a humanizing insight. Inside the court's private conferences and lunches, personal goodwill often prevails over political division. What about Justice Gorsuch and Justice Brown Jackson? One of the newest odd alliances that emerged in the 22 to 23 term were between Justice Gorsuch and Justice Jackson. Justice Gorsuch and Jackson found themselves in agreement in at least 4 cases that term, 1 majority opinion and 3 concurrences, all in favor of limiting government overreach. For example, in a property rights case, Tyler v. Hennepin County, the court unanimously ruled for a 94-year-old homeowner whose condo was taken and sold by the county for unpaid taxes. But Gorsuch wrote a separate concurring opinion joined only by Jackson to stress an additional principle, that keeping the excess sale proceeds was an unconstitutional fine by government. This libertarian streak of protecting individual rights against state power saw the Trump-appointed Gorsuch and the Biden-appointed Jackson standing shoulder to shoulder. It's a pairing few predicted, and it highlights how each justice's unique judicial philosophy can lead to cross-ideological common cause. Gorsuch, a Westerner with cowboy flair, has a deep skepticism of government authority, and Jackson, a former public defender, shares a passion for guarding personal liberties, a principled overlap that blossomed in these cases. How about Chief Justice Roberts and Justice Kagan? Another noteworthy alliance is the pragmatic partnership between these two. Roberts, as chief, is deeply concerned with the court's institutional legitimacy and often seeks moderate consensus outcomes. Kagan, a former Harvard law dean, is known for her candor and skill at building coalitions. Perhaps not surprisingly, Roberts and Kagan voted together 82% of the time last term, more than Roberts did with some of his fellow conservatives. Together, they've crafted narrow decisions in contentious cases, looking for middle ground solutions. In the 2023 term's Big Voting Rights Act case, Allen v. Milligan, it was Roberts, joined by Kagan and others, who authored the majority opinion affirming protections for black voters, surprising many observers. Justice Brett Kavanaugh joined that coalition as well, and he too has forged a friendly understanding with Kagan. In fact, Kavanaugh, Roberts, and Kagan often form a centrist core in cases, exemplifying the court's capacity for ideological diversity within unity. These relationships are not just strategic, they're built on mutual respect. Each of these odd couple stories, and there are more, offer a message of hope about the Supreme Court, that neutral principles and personal respect often trump partisan labels. The justices, of course, have real and deep disagreements on matters of law. But as these alliances show, those disagreements are often in good faith, and they sometimes produce surprising alignments that reaffirm the court's independence. So is the Supreme Court driven primarily by partisan divides? The evidence says no. The past two terms demonstrate a court that, more often than not, speaks in a unified or at least nuanced voice, even when ideological fault lines emerge. The justices frequently defy expectations by crossing over or finding common ground, and behind the courtroom arguments lies a web of collegial relationships and personal bonds that have long been a hallmark of the court. This is not to say that the court is never divided or that ideology plays no role. It does. But the narrative of a hopefully partisan court falls flat when confronted with the actual record of consensus decisions, the data on cross-aisle voting patterns, and the genuine friendships that bridge philosophical gulfs. As Justice Sandra Day O'Connor once observed, the judiciary has no influence over either the sword or the purse. Its power rests only in its legitimacy and the public's trust. That legitimacy is strengthened, not undermined, by the court's demonstrated ability to transcend politics and rule impartially. I'm Benjamin Barr, and my job as a constitutional litigator is to give you the tools necessary to resolve today's constitutional controversies. Thank you for being here today. Please take a moment to like and subscribe as it helps our educational project. And please join us next week as we delve into yet another constitutional controversy.